Ladies and gentlemen, I welcome all to my channel. I am Raziaq Law Advocate. Today in this video, we are going to see which one is best, will or settlement. Which is preferable, which is advisable among the settlement and the will. Before going to this topic, first let us know what is meant by will and what is meant by settlement. Settlement is a transfer of property from one person to another person by which the property is transferred immediately from the donor to the donee. That means from the giver to the taker. Supposing a father wanted to give his property to his son through a settlement deed. Here, the father transfers the property to his son, and the property automatically goes to the son immediately on the registration of the settlement deed, and the son gets title over the property immediately. So this is called settlement. Here the father may give his property for consideration or without consideration. Consideration means some amount. So suppose this father wanted to give the property to his son with some expectation or with some conditions, or he stipulated some conditions, means that will be called as a settlement made for conditional settlement or settlement made for consideration. So assuming that the father settled the property to his son and says that he has to maintain the father and mother till his lifetime, he has to provide all maintenance, food and shelter, everything till the lifetime of the father, then it is called a settlement made with some conditions. Instead of that, the father may, without any condition, without any stipulation, can give the property and transfer the property out of love and affection. So this is called settlement without any consideration. I mean settlement without any receiving any amount. So in settlement, the property goes from the giver to the taker immediately at the time of making or registering the settlement deed. On the other hand, will means it is a desire of a person, it is an intention of the person which is simply recorded in the register office. Supposing a man makes a will and says that I have property A, this property A should go to my son after my death, and I have another property, namely B property, this property should go to my daughter, and I have another property, is a C property, that property will go to my wife, and after the death of my wife, the property C will be divided, should be divided among my son and daughter equally. So supposing a man write this in his will, here the man records his intention, records his desire in the will. So just by registering the will, the property will not go to the persons, to the son or daughter or to the wife. Here the person executing the will only records his intention or desire which is to be implemented after his death. So the will came into effect only after the death of the testator. Testator means the maker of the will. So the will came into existence after the not immediately upon the execution of the will, but it will came into effect only on the date of death of the testator, that is the maker of the will, on the date of the death of the maker of the will. So, supposing a father execute a will today and says that my property A should go to my son and property B should go to my daughter and property C should go to my wife. As said already, the property is not transferred to son or daughter or wife immediately on the time of registration. Once he dies, automatically this will came into effect and the property goes to father, son or daughter or to wife as per the desire, as per the dictation, as per the bequeath made in the will. Assuming for a moment, after making a will, supposing the father wanted to need some money and he wanted to sell the property. So, suppose the father in needs of financial crisis decided to sell property A. Then what will happen? The property which is bequeathed to son, the property which is intended to be delivered to the son, the property which is intended to be transferred to the son is got sold. Now property B and property C alone remains. Now under these circumstances, if the testator, that is the maker of a will, wanted to cancel the will, he can go to the registrar office and say, he can cancel the will. Here, he can cancel the will. One more question is there. Supposing the father makes a will and wanted to sell a property during his lifetime. Can the son can question the sale? No. In will, the property is not transferred to son. The property did not go from father to son. So, the son cannot make any claim. Son's right will come into existence only on the date of death of his father, on the date of death of his testator. So, till the death of the testator, the son will not get any right or property, any share. So, he cannot question. On the other hand, supposing a person settle the property to his son by way of settlement deed, and if he wanted to sell the property, can he sell? No, because that is by way of, in the settlement, the property transfers from the giver to the taker, from the transferor to transferee, from the settlor to settlee. So, in settlement, the property transfer from the father to son, so father cannot have any right to sell the property and son alone can sell the property. So, this is the difference between the settlement and the will. Regarding the expense part of is concerned, for making a will, you need not pay any stamp duty or registration charges. Merely a nominal amount of around 100 rupees will come for registration charges for a registration of this will. Even if the property is 1 crore or 10 crore, 20 crores property, the registrar will look into the value of your property. Because it is merely an intention. Mere intention of the parties is recorded. So, anytime he can come and cancel his will. So, will is always the cancelable one. You may ask a question. Suppose, can I insist my father to make a irrevocable will? Can I ask my father or mother to make a uncancelable, irrevocable will? No. The answer is no. Here, the will no property is transferred from any person, father to son, or from one person to another person. Here, in executing the will, it is merely a recording of the intention or desire of the testator. So, what should be done after his death? What property should be disposed? In what manner it should be disposed? He can record his intention, his desire in the will. So, there is no transfer, so no stamp duty is required for a registration of the will. On the other hand, if you make a settlement deed, now the registrar will look into the value of the property, because here the property is transferred from person A to person B, from father to son, the property goes. So, it is a clear-cut transfer of the property. So, the registrar will insist the parties to pay the stamp duty and the registration charges. Now, you may ask me a question: how much will be the expenses for registration of the settlement deed? So, even in the settlement deed, there are two types of settlement as far as the registration aspect is concerned and stamp duty aspect is concerned. As per the present Stamp Duty and Registration Act, if the settlement is made within the family members, then the maximum stamp duty is around 25,000 and the maximum registration charge is around 5,000 rupees. So, total cost which is to be incurred towards stamp duty and registration charges will be 30,000. 25,000 is towards stamp duty and 5,000 is around 5,000 is about registration charges, and another nominal expenses will come our computer receipt, computer CD and other things. So, the total cost which involve in settlement is around 30,000 rupees. If provided that the settlement is made among the family members. Now, you will ask a question: what is meant by family members? Who are all will come within the family members? It is an interesting question. Initially, the registrar department and the registration authorities named that family members means and include only father, son, daughter, wife, children and grandchildren. So, if a father makes a will to his son, daughter, grandson, grandchildren or to his wife, it can be treated as a settlement deed within the family members. If the person gives the property to any other person other than this relationship, then it will be named as a settlement out of family members. Then in that case, it will be charged like a conveyance deed, that means a sale deed. So, supposing an unknown person Ramu wanted to transfer the property to Thomas, here there is no relationship. In that case, it will be, even if you make a settlement deed, it will be considered as a sale deed. It will be considered as a conveyance. In Stamp Duty Act and Registration Act, they don't use the word sale deed. All the deeds other than those specified in the schedule table will be considered, will be named as a document called conveyance. So, sale deed is one of the sale deed, it only means that sale deed is called as, otherwise called as conveyance. So, conveyance deed. So, for conveyance deed, you will have to pay stamp duty around about 7 plus 4 plus, so 7% registration charge is stamp duty and 4% is registration charge, total will come around to 11%. So, it depending upon time, it also varies. Initially, 13% was there. Now, at present, it seems that 7 plus 4 to 11, it will come around 11%. For the settlement made out of the family members. So, if the settlement is made within the family members, then the fixed stamp duty of 25,000 and registration charges of rupees around 5,000 will have to be incurred. Now, after seeing all these things, you will be knowing which is preferable to you. So, you cannot simply say this one is advisable or this one is advisable. I cannot say will is best. I cannot say settlement is best to you. Depending upon your situation, depending upon your requirement. Supposing you feel that your son will take care about you or your daughter will take care about you, you wanted to give this property to them permanently, immediately, and you do not expect anything from them, you have another properties and you can maintain your life out of your own other properties, then it is better to go for settlement deed. If you fear that if I give the settlement deed immediately to my son or daughter, they will not look into me, they will not maintain me, they will not provide me food, they will not give me shelter, they will not look after me. If you fear like that, you may go for a will, because in will, the property is not transferred from you to your son or daughter. You will have the title over the property, you will retain the ownership over the property, so you will have the whole. The one of the minus point in the will is that the will has to be probated later. So, just by registering a will, you cannot expect that it will be automatically, the property will get transferred automatically. If you make a will today and give your property to your son, after your death, the son will have to take the will copy, registered copy of the will and produce it before the High Court or District Court and obtain a order called probate. They have to get a probate. So, the probate is the official recognition of the court that this person has executed a will like this. This person has desired to transfer his property to his son or daughter. So, this will have to come into effect. Like that, the court will pass an order. For passing this order, the High Court will charge a fees of around 3% towards the bounty charges. So, if you go for a will, though you did not spend any expenditure towards stamp duty or registration charges at this juncture, your son or daughter or your wife or to whom you give the will, execute the will have to bear future case expenses. So, another about 3% of boundary charges they have to pay 3% boundary charges towards the value of the property to the court to get the probate order. In addition to that, other expenses will also there. They will have to pay advocate fees and drafting fees, filing fees, everything you will have to pay. So, that has to be borne by your son or daughter who you give the property. One more minus point is that, supposing you give the property to your son and you do not want, suppose you have 4 or 5 children and you decided to give one property to one son and you do not want to give any share to other children, and if you make an executive will, then after your death, all the children, all the legal heirs of the deceased has to go to the court and submit a consent that this will has been executed and this property has been given by father to this first son. Like that, you have to give a consent. You have to give a consent to the court to pass a order on probate. So, otherwise, suppose there is dispute, they did not give the consent and they did not cooperate with with among the family members, at least any one of them do not cooperate with the people, then it will be a problem in getting the probate. So once the will is executed, it has to be probated. That probate application can be filed either in the High Court or in the District Court. For filing such a probate application, all the legal heir has to sign the petition and give consent, and all the legal heirs has to jointly request the court to pass probate order immediately. If all the people give cooperation, give consent, sign the petition jointly, then the court will take at least 3 to 6 month period to pass an order, and they will get another 6 month period to obtain this probate. On the other hand, suppose any one of the legal heir is not willing to come forward to give consent, and they are not ready to give consent, and they challenges the will, in that case, the court will take it as a disputed will, and it will be taken as a case, and it will go for a long time. The court will take it as a lengthy time to decide and pass appropriate order on the will, on the petition for application for probate. So the second minus point is that if you want to give the property to your son or daughter, excluding other people, it is not preferable to make any such will, because they will unnecessarily go to the court, they will unnecessarily fight and unnecessarily waste the time, energy, money, everything in the court. So it is not advisable to make any such will when you wanted to exclude some of the legal heirs, some of the and to give the property to any particular son or daughter. So these are all the difference between the will and the settlement. So depending upon your requirement, you may choose will or the settlement. As far as the will is concerned, the witness is a must. You have to get two witnesses at attestation. Even for a settlement, 2 witnesses has to sign. Here, the witnesses has to specifically declare that I have personally seen the person who made the will, and who had knowledge about. He has to acknowledge that the person has made the will with his free consent and with his own intention. So these are all the difference between the will and the settlement. So you may choose which one is required to suit your requirements. So we cannot generally say this one is better or that one is better. Depending upon your requirement and circumstances, you may choose any one of the things. I hope this video will be useful to you in transferring or settling your properties to your children or grandchildren. If you have any doubts, you may also call me. You can also see my channel Sattam Arivom, Raziaq Sattam Arivom in Tamil, which is in Tamil, and Raziaq Law Tube, which is in English. My various videos posted in this video will be helpful to you to clear your doubts. In spite of that, if you have any other doubts, you may also contact me either to our phone or in person. We are ready to give you the necessary consultation. And I also request you to give your suggestion about this video, and you may also make your doubts in the comment section. This will also help. That will also helpful to me to make additional videos on additional subjects. I hope I hope this will be useful to you, and I will see you again next time with another topic. Until then, goodbye. Raziaq Ali.